The ACC amends their lawsuit in reaction to FSU's lawsuit. Let's get into the details.
Conference expansion and realignment is always in the news, so we're back on the big mountain to break it down for you.
Hey, it's great to have you here on the mountain. Steve, we have some partially breaking news. Just happened yesterday. I think it'll be a few days till we get this posted, but for us, it's about as breaking as it's going to get. But we had the ACC amend their lawsuit on January 17th, and they've added some things to this. So the headlines that you're seeing here really were the four claims that they've added to this. That's, I look at some of the headlines, as we've said before, the ESPN reporting really focuses in on, and others, but really focuses in on those claims. There's some more detail to this, very much in reaction to the FSU lawsuit, that I want to break down here as well. I don't think you're going to see this in too many other places, unless you actually read the lawsuit, quite frankly. But for those subscribers, they know that's what we like to do here. We like to go a little deeper than most. We like to talk about this a little bit more. But if you're new to the mountain, I'm JY. This is my good friend Steve. And I just want to say right up front, we are not lawyers. We don't claim to be lawyers. But we like to look into this stuff. We both have backgrounds that, again, not lawyer backgrounds, but educational backgrounds that lead to some of these types of things. We can put our little bit of thoughts into some of this stuff. But we're laymen. These are not opinions of lawyers. We don't claim to be lawyers. The other thing before we get into this, I do want to do a shout out. The last one we did was about the grant of rights and really diving into the grant of rights. We used one article on that, which was back in May of 2023. And we kind of broke it down. I'll put a link up here for anybody that didn't see that. I know all of our subscribers have probably seen it, but if you're new to the channel, we went into that and we looked at it from one person's report, Dennis Dodd, and it was before any of this stuff really broke. And he was going over whether or not it's a breakable or is it ironclad, and we dove into that. We had two people comment, and I'm going to call them out because I appreciate it. We had a Scott K, and I think it's a Comby, I think is how you say it, Comby 1, that both referenced another, it wasn't an article, but it was a Harvard Law Review where somebody went down, really broke things down. It was from back in 2017, I believe, but still, again, you can use a lot of what they were talking about there with the grant of rights in terms of what will or what won't work, what will, won't, in their mind, what won't hold up in court.
Right.
And so, we're going to do a deep dive on that as well. We'll get that out next week. I think this is obviously a little more breaking right now, so we want to get into the amended lawsuit, but I want to say thank you to those two commenters. I don't know if they're subscribers. Hopefully they are, and they're seeing the little shout out, but we're going to be doing another episode specific on that, and we also have another one. I saw a legal firm do a write-up on this, and some pros and cons to the grant of rights, where maybe there is a little bit of opening for the FSU lawsuit. So we're going to do a separate one just on that. But let's dive in to the amendment.
And I'll say, to tag along with what you said, for us, this is about discussion. We're going to do a lot of different episodes and just have discussion.
Yeah.
There's a lot of points of view out there. You will see people that are 100% certain that Florida State is in the right and everything is going to be perfect for them and whatever. And then you will see other people who are equally as intelligent think that the ACC has this lockdown and tight and whatever. We want to look at all perspectives and just have a discussion. If you're looking for the most recent breaking news, the headline, that's ESPN. Pull out your smartphone, look at your app, your ESPN headline. If you want those headlines and you want maybe just a little blurb or a little quote, that's what they're going to give you. For us, we're just two guys. We're having a discussion. Like JY said, our professional backgrounds are more in kind of, government and education, where that meets. We deal with lawyers. We're not lawyers.
Right.
We have to listen to input from lawyers. So for us, this is just a discussion, just two guys. And each episode is going to look at a different part of the discussion to give people a full and deeper picture. So that's what we're trying to do.
Yeah, so we did a video a while back on the original lawsuit. Let's dive into this amendment, because a lot of this, I think, really comes out of the FSU lawsuit. So if you don't know what's going on, ACC files first in North Carolina, one day prior to Florida State filing in Florida. We're going to get into that a little bit more in a couple of these videos that I talked about, episodes here in the future and next week, where they talk about that a little bit and what does that mean for jurisdiction. I'm not going to get into that today, but we will be doing an update on that. If you want to see the video, the original video we did, you can go to our channel. I'll put a link up here as well. You can go back and check that out. But let's dive into this. As I said, in the beginning, they have this introductory paragraph. They call it a summary of claims. It talks about what, why they're doing this filing. They added to that this time that FSU now has a material conflict of interest as it continues to participate in the management of the conference, even as it breaches its contracts and seeks to undermine ACC's purpose. Their actions also violate fiduciary obligations to the conference. So both of those things sound very similar to what FSU said about the ACC in terms of the ACC is breaching their contract, the ACC is breaching their fiduciary responsibilities. In this, because of the lawsuit, I want to be clear, I think these were added because of the lawsuit, and we talked about before, could this get to the federal level? And I read specifically that it said, there needs to be an action. They have to act upon something in order to get it to the federal level. That FSU lawsuit was the action, in my opinion, was the action. We're not there yet, but I think we could easily get there because of that.
FSU tried to kind of couch it as not an action, as
right.
a, hey, we're just exploring this, and depending on how this goes, we might take action.
Right.
But obviously the ACC, in their response to this, they're taking it as FSU took an action and is actively trying to get out of the conference.
100%. That's exactly going to be the theme as we go over most of this. You can agree, you can disagree, but that's what you're going to hear from the ACC side. The ACC, as I said, now added 4 new claims to their lawsuit, which is a total of 6. We talked about the 2 claims originally. They add 4 more. We're going to get to that towards the end of the video, but there's a few other pieces within their lawsuit. The claims are at the end, and I'm gonna talk about this as you read their lawsuit. There's several other, specifically 3 other that I want to talk about, sections of this document that I think are really important. So we'll get to those 4 claims next. Those are the headlines. If you've read the articles, you probably have seen what those new 4 are. They also point out that member institutions specifically have authorized the ESPN agreements. I want to be clear. The ESPN agreements are not the same thing as the grant of rights. These are 2 completely separate documents. I say that for 2 reasons. One, I want to make sure everybody is aware of that. It's not the grant of documents is the ESPN agreement. No, these are 2 separate documents, but I also say that because it's going to be talked about in one of our upcoming episodes in terms of how the lawyers are thinking that could be a good or a bad thing in terms of these being 2 separate contracts.
And I think a good, a layman's way of explaining that is the grant of rights is basically all of these schools coming together and giving their media rights to the conference.
Right.
And telling the conference, hey, you take these media rights and you go get the best deal you can.
Right.
And then separately you have the deal with ACC, with ESPN,
right.
and those being 2 separate things. And that's really what they're trying to establish, and I think that's a good way for people to think about that to understand it.
Yep. They also add that North Carolina law allows an unincorporated association, like the ACC, to assert a claim against a member, FSU. They claim that FSU consented to the jurisdiction in the state of North Carolina for all lawsuits. Whether or not that sits or not, I don't know. But again, I'm going to ask you to come back. We're going to get another episode out early next week that addresses that from a lawyer's point of view. So let's get into this. A new section was added to their lawsuit. Entirely new, 7 paragraphs long, that's titled Withdrawal Payment and Alternative Performance. They state at the board meeting in September 2012, there was discussion regarding if the withdrawal penalty and alternate performance should be increased to better protect the conference. And we've talked about some of this, but again, I want to talk about what's in their lawsuit. They go on to say, a media consultant at the time indicated a loss of revenue because of media rights alone could range from $6 to $18 million. Again, that's in 2012. That's a decade ago. $6 to $8 $6 to $18 million if one member withdrew. Over the 12 years of the life of this media agreement, that one member could cost $72 to $200 million. Remember, the severe withdrawal penalty, as is sitting here today, $130 million. So right in the range of what this media consultant is saying. The presidents also acknowledged other lost revenues. So that was just media revenue. But they'll also have, with potential lost revenues from NCAA basketball tournaments, from bowl agreements, from ticket sales, and then kind of the more non-monetary, at least upfront, issues of the ACC's reputation, the ACC's image, and their branding. And what happens to the ACC if one or two look to leave? What does that do to their image? We can kind of see right now how it's very polarizing to the ACC. You're either with ACC or you're with FSU, or you're like us, where we're just bystanders trying to figure all this stuff out. Because of this, it caused the presidents then to increase the withdrawal penalty from 1.25 to 3 times the annual operating budget. This withdrawal penalty is a vehicle through which a member may choose to terminate its membership with the conference and constitutes a form of alternate performance that represents a fraction of the losses sustained by the conference for member withdrawal. You can probably take issue with the whole fraction of a loss, but clearly they're saying if you want to get out, you can get out. You just got to pay the withdrawal penalty. Anything on that? Because then I'll get to the next piece that they added.
No, keep going.
Okay, so they added more background in terms of the 2016 amendment. This was a big one for them. So in 2016, the amendment was needed to extend the term. This is in the ACC's point of view, and to me, a lot of this makes sense when you read it. And I'm not reading it with ACC colored glasses on, but in 2016, an amendment was needed to extend the term of the grant of rights through 2036 in order to establish and operate an ACC network. We've talked about that before. That was the big deal. That was the big reason for that amendment, was to get up an ACC network. 2016. It was further necessary to provide content for the ACC network. Absence a certainty as to the duration of the agreement, aka the duration of an ACC network that's to be built, the network would not be marketable to cable providers. That only makes sense to me. Thus, the grant of rights was extended to be basically run congruent with the life of the ACC network. If we're going to get it up and running, we want to ensure that it's going to be around for a little while. And according to the ACC, that was the main gist behind that.
Basically, they're saying that if they can't guarantee who the members of the ACC are going to be, they can't market a deal with cable providers to, hey, buy this ACC network, give us a contract for however many years that you're going to want this. If you can't guarantee these are the teams that are going to be playing on it.
These are the teams. These are the number of contests. These are the If you go from a conference of 14 down to 8, that's way less live broadcasting of athletics that you're going to have. So yeah, it makes sense. It also provided predictability and substantial sources of revenue for the members. Before the execution of the 2016 amendment, the conference held multiple meetings with legal counsel for the members, the presidents, the ADs, and what they call the faculty athletic representatives, or they call it the FARs. This was in addition to on-campus meetings with various presidents and stakeholders, and also conference calls with members' attorneys. The FARs, these faculty athletics representatives, met, and the FSU FAR actually chaired a meeting on June 22nd, 2016, in which the FARs voted to unanimously move forward these agreements to the Board of Trustees. So you could say this was maybe the first committee that it had to get through, then it moves on and whatnot. So fully unanimous consent of that. They lay out several more dates. I'm not going to bore you with all of these dates, but by the end of June 26th, they've gotten through all of this. And then they had discussion, and FSU was present prior to the June 28th, 2016 execution by FSU. So it all happened the mid to end June 2016. Certainly lots of conversation before that, but all the actions occurred the end of June of 16. Another new section that they add is, and this is purely in response to FSU's filing. This one is stated, Florida State carries out its plan to breach its agreements, interfere with the ESPN agreements, and reveal confidential information that is a trade secret. So they're pinging all the important words here. I will say this section comes after, and then they had a section in their original lawsuit that talked about FSU plans to do this. Now, of course, they're adding, okay, they did it. So they were planning it, and now they did it.
And can I point out real quick, in our previous episode when we talked about the legal strategy behind creating the grant of rights originally with the Big 12, and then as the ACC pretty much adopted it, a big part of that was trade secrets.
Yes.
And how that gets involved in federal law.
Yes.
So I think that's interesting that they cite that, the trade secrets.
Yes, thank you for bringing that up. You know, again, if you didn't see that episode on the grant of rights, you go back and check that out because we get into a little bit of that. How, you know, what laws were used if it gets to the federal level. Trade secret was a big part of that. So let's get into this. The ACC claims that FSU did not follow their board policy on notification of the December 21st Board of Trustees meetings, December 21st, 2023. It was not met for a normal operating meeting or for an emergency meeting. With the knowledge that FSU's intention was to breach the grant of rights, the ACC filed its complaint on December 21st after receiving notice of the alleged emergency meeting by FSU's Board of Trustees. During the emergency meeting, no member informed the public, and they go through the members, the president, the legal counsel, the trustees, nobody informed the public of the nature of the emergency that had necessitated less than the statutorily required notice. Now, I can't say if that's true or not. I would assume there's documentation to back that up, but they're kind of poking holes at how quickly this was done, and it did not follow both their board policy and the required notice for a public meeting. Remarks made by the members revealed that FSU had already decided to breach its agreements and reveal confidential information as the chairman spoke of individual briefings. This is between the Board of Trustees of Florida State, from member to member over the course of several months. These actions were intended for the purpose of avoiding the applicability of Florida's Public Meetings Act. FSU retained a copy of the executed grant of rights and provided it to the public. A copy of the grant of rights was posted to the website War Chant. They actually give the name of the person. I'm not going to say it here, but I am going to say War Chant because I know we've had a couple of our episodes posted to War Chant. So maybe this one will.
We have plenty of friends on War Chant.
Yeah.
Shout out to War Chant.
So that you're in litigate. Well, you're not in it, but you're referenced and mentioned. So I wonder how many clicks they're going to get because they're in this thing.
I mean, anyone interested in this topic's already been on War Chant a ton, but I'm really interested for them to allege this in the suit. That what kind of proof do they have that somebody from Florida State released this and put it on War Chant? If you're going to make that accusation,
apparently there's an email.
That's interesting. I would love to see that.
In the lawsuit, they say there's an email.
Okay.
So, FSU was repeatedly informed in 2022-23 that the agreements were confidential. So they're getting warned. They're getting warned, according to the ACC. The FSU complaint in Florida contained confidential information, and the action did not seek to protect that information. On January 9th, 2024, the conference notified FSU that they had disclosed confidential information. So, the last thing I want to get into are the claims of relief. You want me to keep going?
Keep going.
Keep going. So the first two we already talked about. We already knew them from before. The first was the grant of rights and the amendments are valid and enforceable. The second was they're requesting an estoppel, or they're requesting FSU be stopped and or waived any challenges to the grant of rights. Basically saying they're good. They have to stop from questioning this. Be done with yourselves. They go on now. These next four are they are in reaction to the FSU filing in Florida. Number 3, FSU has breached its promises in the grant of rights. They talk about they took direct action against the validity of the grant of rights with the Florida lawsuit and breached their contract. FSU took direct action against the irrevocability and the exclusivity of the grant of rights in the Florida lawsuit and breached their contract. Item number 4. FSU has breached its obligation to protect confidential information. The reason the ESPN agreements, in the ACC's view, the reason the ESPN agreements are kept under lock and key at the headquarters in North Carolina is to preserve their confidentiality. You can agree with that, you can disagree with that, but to them, that's the reason it was done. FSU violated this confidentiality when it permitted disclosure of this information at the December 22nd, 2023 Board of Trustees meeting in the release of an unfiled version of the Florida lawsuit and then also in the actual Florida lawsuit. Number 5, FSU has breached and continues to breach its fiduciary obligations to the conference. Upon joining the ACC, FSU entered into a common and joint venture with other member institutions. As such, they have a fiduciary obligation to the other members and to the conference. Under North Carolina law, when a member of a common and joint venture no longer supports the goals of the joint venture, it has to withdraw and not act in ways to frustrate the goals of the joint venture. FSU's interests are their own, with no regard to the best interests of the conference. A request, and I found this one of the best parts. If you remember, as we reported, we actually did a separate episode on this because we missed it the first time. But at the end of all of the claims that FSU made, they put a request that if the lawsuit is deemed, if they approve one of the 6 claims or 7, whatever they had,
find one of them valid,
then they requested to withdraw from the conference on August, I think it was 14th or 15th of 2023. They did it in every one of their things. And it's funny because the ACC talks about that. And they say the request for retroactive withdrawal back to August of 2023. The Constitution speaks to the issue of a conflict of interest upon withdrawal. However, FSU, as of January 17th, the date of this filing, has not issued a notice. And I'm not going to get into that, but there are paragraphs within the Constitution that talks about that conflict. Once you have a withdrawal, from that point until you're actually withdrawn, what is your conflict of interest within that? We talked about that with the PAC. There was a lot of stuff. There was a lot that they were throwing back at each other. You can't withdraw publicly but still be a member, and you can't say you don't have a conflict of interest here. That wasn't in the PAC. It is in the FSU Constitution. I'm not going to get into the details of it, but that's what it is. Number 6, FSU has breached its obligations of good faith and fair dealing. They go on to ask for what they call a prayer of relief. This includes 3 things that really stuck out to me, and then I'm going to turn it over to you, Steve. FSU pay for damages for its breaches in the amount to be proven at a trial. A permanent injunction barring FSU from disclosing confidential information, and a permanent injunction barring FSU from participating in the management of the ACC. So I just went through a whole bunch of good stuff, Steve. I know you took some notes.
Yep.
Let's get into it. What are you thinking?
So so reading over this, the most important part of this, in my opinion, that I took right away in my first read through of the amended lawsuit is the last thing you just covered, which is basically taking away their voting rights and their participation in the management of the ACC based on their conflict of interest.
Right.
Okay.
Right.
So that is, to me, that is the most important part of this entire thing. They've basically established Florida State is trying to leave. I think both sides kind of, you know, they're trying to couch it to their own benefit as much as possible, but we've basically established Florida State's trying to leave. And to me, the most important part, and because they're filing in North Carolina, which is where the organization is headquartered,
right?
I think that's the most important part because they can freeze Florida State out of going forward of control of the ACC, all of those things. Very similar to what we saw out in Washington State.
Yep.
Although in this case, there's a much more robust set of bylaws or constitution in this case. So to me, that is the most important part of this.
Agreed.
The biggest part I take out of this. A lot of the other stuff I think is a lot of kind of just tit for tat. We talked about in the PAC case, kind of move and counter move. You file in one state, you file in the other state, and one side makes a claim, the other side makes a claim. A lot of tit for tat, a lot of move and counter move. But that one is a huge one. If they can freeze Florida State out of the determination of what's going forward, what's moving forward, that is huge in my opinion. And they're doing it where they're trying to do it is the proper place to do it, which is there in North Carolina,
right?
Because that's where the ACC is headquartered.
Right.
Now, a lot of the other stuff, I really question the effectiveness of it being in North Carolina versus in Florida. One side obviously, Florida State, that they feel like they're going to have a friendly court in a county outside of Tallahassee,
right?
But also they're trying to apply Florida law to the situation, whereas the ACC, they're trying to apply North Carolina law, and they cite North Carolina law multiple times a day.
Yes.
Okay. So that's going to get me to a couple other larger points.
Okay. One,
which I kind of already touched on, I think both sides have basically agreed that FSU is going to leave the ACC.
Right.
I don't think there's one part in here where the ACC is trying to enjoin Florida State from leaving.
Right.
Everybody has accepted that Florida State is going to leave. And at this point, it's about each side making claims, who's damaged, what's in the bylaws,
right?
Is this legal, is that legal? We're in the first stages of that negotiation, which you and I have talked about. We believe this is going to be to a settlement.
Right.
Going to lead to a settlement. That's where it's going to end. So once you establish that both sides have agreed to their leaving, what are they really trying to do here? So for me, I think the ACC, I think they want to, but I really think they need to get this case to federal court as soon as possible.
Yeah.
There's specific things in there when we broke down the grant of rights, how it was intended, how the Big 12 lawyers created it, and then the ACC brought it over and used it. Almost everything cites federal law, and honestly, the ACC will be in a much stronger position as soon as they can get this case to federal court for a few different reasons. Mm-hmm. One, again, that's how the grant of rights is set up. That's how the structure is set up. But two, I really think they're at a disadvantage where they're trying to do everything in North Carolina. It is kind of a move, counter move, but I think they're at a disadvantage being in North Carolina versus Florida State being in Florida.
Yeah.
Here's why. Florida State is a public institution. The governor there, and we always try and avoid politics as much as possible. I think this is going to be one of those areas, one of those topics. We're going to talk about some politicians and their actions, and hopefully we can stay out any landmines.
Right.
But the governor there and the attorney general have already basically stepped into this, weighed into this, either directly or indirectly. The governor has the ability to appoint board of directors at Florida State as he chooses, basically direct them to do what he wants them to do. And there are particular state laws in Florida, in the state of Florida that we've already talked about, that shield public universities, public entities, which we think, we're assuming Florida State, the university is a public entity. Now, whether or not those will apply to them, a lot of those questions can only be determined in federal court.
Right.
If this case plays out where the ACC is making all their arguments under North Carolina law and Florida State is making all their arguments under laws of the state of Florida, you're going to be at a stalemate. And here's the thing: Florida State is in the state of Florida.
Yeah.
They are a public institution. They cannot pay out any money or any funds. I mean, the judge in North Carolina can say, "Hey, Florida State, you owe $500 million," and if the legislature and the governor and the courts in the state of Florida say no, you are not allowed to pay that money, guess what? That money's not going to be paid unless a federal judge rules it to be so. Yeah. So I think that is the ACC strategy. I'm assuming that. I'm guessing that.
Yeah.
Because I think that's where they need to go. For them to have any chance, I don't think this state tit versus tat in their respective states is going to work out. So Now, another thing with the ACC, I think a lot of this is about limiting the damage, okay? Again, and that's assuming that both sides have just basically come to the realization that Florida State's going to leave. A lot of this is about the ACC limiting the damage. Some of that is financial damage.
Right.
How can they limit the financial damage? What's the most money they can get from Florida State to keep there? But another big part of this is limiting the damages of the number of schools leaving.
Yeah.
Okay?
Yeah.
That is huge. That is really the survival of the ACC is dependent on how many schools can they keep, okay? You and I have talked offline, off camera, about some different scenarios, and I'm not going to go through a whole scenario. Maybe we'll do another episode on that. But you start to think, okay, if the judge in Florida rules that this is non-enforceable in the state of Florida, violates Florida law, you already have the governor and the AG involved. So now the governor basically controls Florida State. So now if the governor of Florida and the AG in Florida say this contract, this grant of rights, the whole ACC, this is not enforceable within the bounds of the state of Florida, okay? Who does that affect possibly?
Yeah.
Miami, okay?
Right.
So now you already have Florida State leaving. You potentially could have Miami leaving. It really starts a slippery slope, a real dangerous ground for the ACC, where they really need to keep things, basically keep the damage limited as much as possible.
Right.
If that were to happen to schools in the state of Florida to leave, does that spill over into Clemson? Okay.
Right.
State of South Carolina, we haven't dug into their laws, but if you have two major powers leaving the ACC, does that spill into Clemson? And then if you get those three going, how does that spill into other states? Sure. And then you start to see a series of dominoes falling that could basically just take out all of the power and the cooperation within the members of the ACC.
Right.
So to me, my biggest takeaways of this, definitely the voting rights, but everything in here, everything in this suit, it all goes back to the need to get this to federal court. That's how the grant of rights was designed. It was citing federal law, and I think that's what the ACC is trying to do as soon as possible.
Yeah.
So one last thing that I think everybody should remember, we talked about this a lot in the Pac-12 situation. Okay, you had public universities, Washington, University of Washington, Washington State University. You had public institutions. We've never had a situation. We had somewhat with the University of Maryland before they kind of sued and countersued, but you never had a situation with a potentially an entire conference before the PAC, an entire conference just dissolving, and a conference that's made out of private universities, private institutions, public institutions that all deal in various state laws. So we're focusing a lot, and this lawsuit is focusing a lot on the constitutions, on the constitution of the ACC. But to me, what is really important is, first of all, the state laws in each individual state, which can differ, and we're dealing with public institutions. And really the only way you overcome that difference, and Judge Levy pointed this out directly at the very beginning of the Pac-12 cases, eventually if this plays out, it's going to go to federal court. So that's something to just keep in mind. Any claims that are made, okay, they make the claim of in the state of Florida, when you have an organization, or the state of North Carolina, you have an organization, these are the rules. Well, how many organizations in the state of North Carolina include membership of public entities from other states? So it's not the same thing as your Lions Club or your PTO or a booster organization. This is a whole big can of worms that is going to end up in federal court. So I think that's pretty much a summary of my overall thoughts. Is basically the ACC, a little bit of tit for tat, but the ACC is trying to limit the damage and get this thing to federal court, which is where they have the best chance of winning, in my opinion.
Yeah, I'll just add a couple things, and I'm going to tease the episode on jurisdiction. I'm going to tease it here. So if you stuck with us this long, we appreciate it. Let me give a couple thoughts on Steve's thoughts, and then I'm going to tease what that at least the one lawyer thinks that it means. So I would say I agree with you. I think these preliminary injunctions that came as the part of the prayer of relief for them, I think my question on that is there a preliminary injunction? I'm going to go back to the Pac-12 because we followed that very, very closely. And once they got to the point of asking for a preliminary injunction, there was a hearing pretty quickly on whether or not the judge is going to rule in favor of a preliminary injunction. Then you that gives them time. Okay, everything stops. You stay where you're at, so there can be no further damage done if they agree that damage is going to be done. And then they get to whether it's a permanent injunction or the trial or whatever the case may be. So my first thought is, hey, how quick are we going to get to a preliminary injunction here? I would think, based on the Pac-12, it may not be that far away if the ACC is going to even ask for a preliminary injunction.
I think
right?
I saw maybe February 18th was their deadline to file for filings for the preliminary
injunction. All right, good. I did not see that. So that's kind of my first thought when we get to that last topic. The other piece is, I agree with you that everybody knows where the end game is going to be, and that end game is FSU not part of the ACC. And the ACC, even as I said earlier, when they added some of this wording, they talk about how FSU can leave, and it's paying the withdrawal penalty, right? Like they're saying, hey, you can leave. Here's how you leave. Yeah. That sounds simple. I know I'm dumbing it down immensely in that, but that is basically what they're saying. And then I also would say, I think the ACC fights this. And when I say the ACC, I mean the majority of the members of the board of the ACC, right? The ACC is not just a standalone entity that does whatever the heck they want. They have a board of all the members that vote what they're going to do. Yep. And as long as they have a majority that want to fight this to the bitter end because they want to keep the ACC alive, I mean, you can see in these, the ACC is digging their heels in big time. Yep. Now, that can change. Members can change their thoughts on that. You can lose your majority. Mm-hmm. Who knows? But at least right now, based on these filings, the ACC is very, very serious about this. Yep. And they are not, to your point, okay, we'll lose FSU. We're not losing anybody else. And we're going to make this so difficult that nobody else is going to want to do it, even if there's a few others that are thinking about doing it, right? So as of right now, it certainly looks like there's a strong coalition that we are going at this as hard as we possibly can. So I said I was going to tease the jurisdiction.
Yes.
I'm going to tease it.
Okay.
So we're going to do an episode just on this one law firm. They put out an article. They talked about 3 different things. They talked about the interstate commerce and antitrust laws and things. So we'll talk about that and where they think that could head, whether there's fire there or not. They also talk about the penalty and whether these penalties are just so outrageous that there's no way a judge is going to, agree with that $572 million. They talk about that. And then the third thing they talk about is the jurisdiction and where is it going to be. And I'm not going to give you the details, but I am going to give you the answer because you stuck with us this long. According to this law firm, because the ACC filed first in North Carolina and FSU filed second, yes, it was a day or two, whatever it was, their opinion is that Florida will stay that hearing because the precedent goes to the North Carolina lawsuit. I'm going to get into the details on the next episode, so make sure you subscribe or at least come back and check with us. That'll hit early next week. May get it out on Sunday, Monday, something like that. But we're going to get into the jurisdiction and why they think, at least where we sit now, federal court aside, federal lawsuit aside, this right now is going to be heard in North Carolina. First.
Yes.
Correct. Stayed in Florida. Right. Stayed until the North Carolina lawsuit's over. So just to give a little bit of well, maybe that's where we're headed. Who knows? So anything else, Steve, before we close this sucker out? We got into a lot of information here.
No, I think that was good. I'm looking forward to the next couple episodes where we can discuss some more.
Yeah, so just as a reminder, we're going to have 2 different episodes based on lawyers' opinions of the grant of rights. Well, really, one is of the grant of rights, one is of the FSU lawsuit, and where they may actually have some advantage over the ACC in this. So, hey, make sure you give us a like on this episode. Make sure you give us a subscribe. I know we've gotten some people sharing our videos out there, which is awesome. Hey, War Chant, if you're out there and you want to share this, we'd love to have you out there. But if not, we thank you guys for watching, and we'll see you guys next time on the Big Mountain.